Good morning. Our job today is to help keep you all out of trouble. However, at 8 o'clock in the morning, well, at any time really, we believe that the best way to learn and to discuss issues is to be active. So this is not going to be just sit back and listen to us blather for a while. What we're going to do is we've got some hypotheticals, a story that we draw on issues that folks in the animal rights world sometimes can get into trouble. We're going to present those to you, and then you're going to figure out what the answer is. We'll break into small groups. Studies have shown that our sense of ethics and right and wrong are best developed in small groups of peers of 4 to 5 people. So we're going to do that today. And also, it's 8 in the morning. We need to get talking and everybody going. So I'll start with the first scenario, and then we'll break up, and then Russ will lead us in kind of seeing what we've come up with. In the meantime, you can enjoy Russ's great images. Well, I guess Russ over there today. Our story is not directly connected to the pictures. They're just good pictures. So here's our story. Billy Miller is an attorney passionate about helping animals. Billy volunteers at several national animal rights and animal welfare organizations. Her main practice area is family law. One of the groups to which Billy belongs is the Red Valley Horse Protection League. This group rescues abused and abandoned horses. One day, the shelter director at Red Valley, Wild Bill Barton, told her about a cruel rodeo event called wild cow milking. This event is terrible. They round up cows with calves and put them in the rodeo arena. Then teams of 2 cowboys, one on foot and one on horseback, chase a cow and rope her. The cow is knocked to the ground, and the cowboy on foot grabs a teat and milks the frightened cow. The first cowboy back to the official with 1 cup of milk is the winner. Wild Bill then asked Billy, "In your opinion, is there anything we can do about this?" Billy jumps right in with a response. "I don't think this would be animal cruelty because this is a rodeo event. I'm pretty sure that rodeo events are exempt from the state's animal cruelty laws. But we could try and pass a state law that would make this illegal." Billy answered off the cuff without doing any research. The last time she looked at the state's cruelty law was a year ago while attending an animal law CLE. "Great," Wild Bill said. "Would you work for us on this?" Billy answered, "Sure, I'd love to." Billy did not think much about the project, though. She had a messy, contested divorce coming up and a disputed international child custody case. 6 weeks later, Wild Bill asked her how the bill was coming. She responded that she'd been busy lately, but would get to it soon. Okay, that's our first scenario. So amongst yourselves, in groups of 3 or 4, decide if you see any potential ethics or even professionalism issues there. Go ahead, take a couple of minutes and figure it out.
So what's the first, biggest, most obvious discussion we should have about this? No research was done. Okay, so how much research do we have to do? I mean, what's our duties here from a professional responsibility side? What are your thoughts? Would anybody here have done this little? Yes, I would.
I mean, I would, if it was here, looking at the statutes, and I hear something that I'm interested in. It's hard to stay up on, do your normal work, stay up on everything. So I would have done my research after having conversation.
How many of you have been in a situation when you're volunteering for a nonprofit and somebody asks a legal question and then you respond? Okay, most people in this room, and I think that's the norm. That's what this segment is to get us to talk about. It's that when we're in a nonprofit situation, when we're volunteering and somebody asks a question, we want to rush forward. We want to be the lawyer in the room. We want to help them with their legal problem. But if somebody was paying us our hourly rate and they ask a question, how many of us would then take back and say, well, here's a preliminary answer, but let me get back with you, or let me check on that, or let's talk this afternoon, or are you free for a meeting tomorrow, or maybe we should bring somebody else into the discussion. and then go back and at least spend 10 minutes on it. I mean, isn't that what we do in our practices? It is what we do in our practices. So it brings up the issue of, are we violating our professional responsibility when we have a nonprofit and we're not doing the same type of thing for? What do we think? Are they a client? I've got a yes. Is an attorney-client relationship established here? Go ahead.
If that's the understanding of the volunteer aspect for the nonprofit, I mean, I'm an attorney, I volunteer for a lot of organizations, food banks or whatever, but I'm not their attorney.
Right. You're not. They're not their attorney. What would anybody here say in this scenario that the nonprofit would say, oh, we thought she was our attorney. She was giving us legal advice.
Yeah.
Yeah.
If they ask a question, you answer. I think you just enter the relationship, whether you like it or not.
And you're exactly right. You're exactly right. I mean, in the field Steve teaches, when you go and you actually look at the disciplinary actions, the people that maybe not have lost their law license over this, but certainly been disciplined. I mean, that's it. If somebody asks you a question about a legal issue and you respond with a legal answer, they have every right to think that you're their lawyer, whether money's changed hands, whether there's in a contract, whether there's anything else. So do you think that this person, this lawyer, was thinking in those terms? Do you think she thought that she had just established an attorney-client relationship with all of the duties that go with it? Thoughts? Probably not. She was sitting there and she got asked a question and she answered. But unknowingly, to her probably, she has just formed an attorney-client relationship, and with that goes the entire code of professional responsibility. This is one of the most challenging aspects of us lawyers who volunteer for nonprofits. Just a little aside, the Manhattan Bar wants me to come out and spend an entire hour on that one point. When do you establish a relationship with a nonprofit? When you're a volunteer lawyer. I mean, that's how important it is to those folks. So keep that in mind in your relationships with these nonprofits. Have you established a relationship? Let's talk about just one last thing. What would be a best practice in terms of not establishing a relationship? Let's say you don't want to have that formal relationship. Is there anything you could say at the time that would make that so you're not representing them? Go ahead.
Not really my area of practice. Please see this person here who really knows a lot of practice.
Okay, one is just flat declined to answer. Other thoughts?
I would answer.
You would still answer. Okay.
I would answer. I say this is what I'm thinking, but this person here is the one who really knows.
Got it. Here's my thoughts as a volunteer. I'm not your lawyer. If you want to hire a lawyer, we need to hire a lawyer, or find a pro bono one, or I could do it or whatever, but I'm not your lawyer. You need to establish that. All right, with that, we'll move into the, now it's really that. We'll move into the next section. Billy did start working on the bill. She looked at existing state law and found an animal cruelty exemption for recognized rodeo events, though the phrase was not defined. Then she drafted a state statute that would ban the event. Next, she called a nonprofit, the Friends of Cows, a vegan advocacy group. She told Mike Korn, the volunteer coordinator, that she was working with Red Valley Horse Protection League to draft a bill banning rodeo wild cow milking. Mike was excited about the bill and suggested Sally Member as a bill sponsor. She is a vegan and wonderful to work with, explained Mike Korn. Mike then asked Billy if she did nonprofit work, as the Friends of Cows needed a new volunteer agreement. They all need new volunteer agreements. The agreement looked pretty good, and Billy made only a few changes in red pencil and gave it back to Mike Korn. Mike asked if the Friends of Cow owed her anything for her work, and Billy said, no, I only charge clients, not the nonprofits I volunteer for. Billy then went to the prospective bill sponsor, Sally Member, to pitch the bill. Sally thought the event was cruel and wanted to sponsor the bill, but Sally then added, let's not just ban rodeo events in the state. Billy was not sure about this and went back, let's just ban all rodeo events in the state. She just wants to ban it all. Billy was not sure about this and went back to both the Friends of Cows as well as the Red Valley Horse Protection League. The Friends of Cows thought that banning all rodeo events would be a great bill. The Red Valley Horse Protection League thought that this was just terrible. Billy found out that the Red Valley Horse Protection League was not against rodeos, just against wild cow milking. The league was also upset that Billy went to Sally Member to discuss the bill sponsorship. The chair of the league's board said, "That woman is a vegan. How can we use her? Many of our members are cattle ranchers who love their horses, love rodeo, love a good T-bone steak, but still believe wild cow milking is cruel." So break amongst yourselves. See if you see any issues there. And we'll be back in a minute.
Okay, let's come back to a committee of the whole. What do we think? First of all, has Billy solved her research problem now? We feel better about that issue. Yes? No? Are we good to go? Pardon me? Well, she looked up the statute. She saw that there was an exemption for recognized rodeo events, though the phrase is not defined. I teach legal writing and research, and if she stopped there, I'm going to say, no. I think if it's not defined, then we have to do a little more work to figure out maybe there's a case or something out there, or regulations, or some other, just looking at the statute isn't going to be enough. Okay, so if we get past that issue, is there anything else that we saw that Billy's should be concerned about now? I know there must be, because I heard lots of conversation. Yeah.
Should not be revising the volunteer contract unless she's familiar with employment law in her jurisdiction, as well as multiple other statutes and sets of regulations that might interact with that and contract.
Okay. So just kind of saying, oh, it looks good to me. Here's a little editing suggestion that seemed a bit fast and loose, maybe, of a way to practice law, a good way to get herself in trouble. And of course, her area of expertise is family law. Maybe she has a lot of experience with volunteer agreements in family law, but it seems probably not. So that looks like maybe we should have required another work. But what about even before she agreed to look at the volunteer agreement?
She had a conflict.
A conflict?
Yeah, two parties.
A conflict between the Friends of Cows and the Red Valley Horse Protection League? Possibly. What's the conflict there?
Well, I feel like they may have similar goals, but there's at one point a divergence. But we were talking about how it's not exactly like having two criminal defendants where, one of them starts pointing at the other. So I don't know if that's, current conflict, but it seems like we have an issue.
Okay. Does anybody think it's not a conflict? It looks like a problem to me. Everybody thinks there's a conflict there? That if you're, okay.
Under the model rules, I'm not sure there's a conflict because she's not representing matters, but not the legislation, so it would be unethical. I'm not sure if it's violating the rules.
Okay. Well, first of all, is representing someone in pushing legislation, is that a matter? You think that's not a matter under the rules? I don't know. I think it could be. Matter is defined pretty broadly, but I still agree with you. I'm not sure that there's a conflict. There's not a direct conflict. It's not, as I tell my students, if you can look on the opposite side of the V, like AV versus B, if you look on the opposite side and there's a client there, you have a conflict. If there's not a client on the other side of the V, you still might have a conflict, but that's what a direct conflict is, whether it's in litigation or in negotiation. The buyer and the seller, you can't represent both. Okay. But this isn't that. These organizations are not buyer and seller. They're not plaintiff and defendant. They just disagree with each other. Can we represent people that have different points of view?
If you've made disclosure to both clients that you've got to do this and ask for objections, if any, and if they both say, yeah, that's fine, I think you can go ahead and do it.
Okay. Now, what about, though, Red Valley Horse Protection and say, we can't use her. Because she's antithetical to our members. Because after all, she's a vegan. That's like it's a dirty word to these people. Because they're ranchers. Is that a problem? It looks like it's a problem for the client. First of all, before we even get to a conflict, are we representing Friends of Cows? Once again, she hasn't made clear what she said. Oh, I don't charge people I volunteer for. I only charge my clients. Has that done the job as far as saying, okay, you're not my client. I'm just doing volunteer work for you? No way. No. And just because you don't charge doesn't mean the person's not your client. So there's a problem. There's a conflict. But
it also feels like she doesn't have sort of a scope of work or whatever. So she went to this representative and said, hey, blah, 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 blah about this bill, when the Red Hill, whatever it is,
Red Valley.
never asked her to do that, never did. It sounds like didn't even know she was doing it. So if she has a client relationship, she also has a problem that she's speaking on their behalf and doing things that they never asked her to do. And she hasn't even checked out yet what their goals actually are. So there's...
Yeah, she's kind of going off on her own here, and apparently in a direction that the Red Valley doesn't want her to go. There's even the potential, it seems to me, of client confidences, that they're considering pushing this bill, and she's going and telling people that may be at odds with their bill. There's at least that potential. She should be working with her client a lot more closely before she goes off and finds the sponsor for the bill. Okay. Which I think there's also not just whether there's a precise, an actual conflict. There's questions of professionalism here, which is the way as I define things. Ethics that's our minimal ethical floor below which you cannot fall. If you fall below that, you're going to get sanctioned. But there's also professionalism, which is what we aspire to be, just something more than that. The norms of how we should act as lawyers, and certainly keeping our client informed is one of those things. Okay? It seems to me that this is a problem that could be resolved, at least as far as, gee, we don't want this person sponsoring our bill. It's like, well, the more people we get behind this, the better chance we have of passing it. If you can explain to the Red Valley horse folks that our interests are in common, we might be able to work this out. On the other hand, they seem pretty adamant about it, but that's what we need to do in terms of talking with them and making sure that our client understands what we're doing. I think that's right. And it looks like I'm out of time. We've got to move on to the next one.
Yeah. Go ahead and read the next piece.
Okay, so on to the next one. So, Billy thought that an outright ban on all rodeo events would not pass the legislature. She decided to try and salvage the relationship with Red Valley in order to pass the anti-wild cow milking bill. How about if I find a rural bill sponsor that is pro-rodeo, just anti-wild cow milking? Billy said to the Red River executive director, old Wild Bill Barton. Wild Bill said, okay, go ahead, but just to be clear, this is our bill. Billy did mention to Wild Bill that it was not clear if wild cow milking was considered a recognized rodeo event and may not be excluded from the state's cruelty laws. She told Wild Bill that she may be able to persuade the county prosecutor to file cruelty charges against the rodeo participants who milked wild cows in this way. Billy said in doing so, she would act on behalf of Red Valley, but would need $1,000 to cover some of her time. Wild Bill told her that a wealthy donor, B.F. Franklin, would probably give her the money to do the work for Red River. Billy called B.F. Franklin, who loved the idea of trying to get a criminal prosecution for the wild cow milking event. They met for coffee, where there was an immediate attraction between B.F. and Billy. It's interesting here. B.F. Franklin peeled off 10 $100 bills and gave the money to Billy to do this work. Billy put the bills in her hip pocket. Billy went to the prosecutor and showed her a video of the wild cow milking event. The prosecutor asked her about the public's perception of the event. Billy said, 70% of county voters agree with the ban. Actually, 70% of the members of the Red Valley Force Protection League agreed with the ban, Billy had no idea how the bill would pull statewide or even countywide. Billy then created a WordPress website promoting the anti-wild cow milking bill. She wrote weekly blogs on the site, explaining the bill's progress and blogging about the cruelty of the event. One day she found the following comment posted on the site. I am a local cowboy and participated in the last wild cow milking rodeo event. It is not cruel. You city folks are just out to ruin our rural lifestyle. Billy could not resist and pounded back. You're just a sick dime store cowboy compensating for your small life with a big belt buckle. If you want to keep out of jail, you better not enter this event again. Oh, and get a good lawyer, buddy. You're going to need it. The other blog comments that followed all supported Billy. So, any other issues come to mind? Go ahead, talk amongst yourselves.
All right. So how's Billy doing? Billy needs a, what was it coming? Billy needs a new job. She needs a real job, right? Stop this volunteer work. What do we see? What are some, well, let me just throw out a question. What about the comment that she needs $1,000 to cover some of her time? Anybody see any issues with that from a fee perspective? Is that clear enough? Thoughts? Go ahead.
You gotta get a retainer agreement there to say what's on the clock and what's not on the clock.
Clearly, a best practice is a retainer agreement. Now, I won't ask how many of you have ever represented a client and not gotten a retainer agreement, because I think I might know the answer. But certainly, a retainer agreement is a best practice in almost every case, so that you can lay out such things as what? What should be in a retainer agreement? The retainer, first of all, yes, there's an attorney-client relationship, which we seem to have an issue with in here. What else? What else? Scope of work. Good. Does she represent them? What does she get for $1,000? Any of us ever found ourselves in a situation where you've been hired to do something, there's some money discussed, and then the project seemed to expand and expand and expand, and you're not getting paid for your time? Raise your hand if you've ever heard of that happen. Yes. Yes, certainly we don't want to be in that boat from a practice standpoint. How about rate? Do we have to let people know what we're charging them? Can we just say, we'll charge you something, you know?
Well, she can negotiate a flat fee, I think. That's okay, but again, it needs to be laid out and clear.
Right. There's nothing wrong with a flat fee. In fact, you know, there's a great trend. We go to seminars and we hear about new flat fee agreements and how this is what in particular organizations want for billing. But you have to, again, scope of work. For $1,000, you get this, you don't get that. Some of the best fee agreements I've seen also actually exclude things. We're covering A, but we're not touching B, because you can see that there might be something that is tangential that you could easily creep into and you don't want to be into. But what else? What are some other things that Billy needs to be thoughtful of and clearly hasn't even thought of or totally ignored? Go ahead.
Third-party payment.
Third-party payment. So can you accept payment from a third party for legal fees? Yes. And of course, we see it all of the time. I mean, people pay for other people's legal services all the time, but what are we up against in terms of restrictions?
Confidentiality to have that clearly disclosed that who your client is and payment doesn't give kind of.
So we heard two comments. Comments from the floor. One is confidentiality, and the other is attorney-client privilege. So confidentiality. Do you owe anything to any duty of confidentiality to the client when somebody else is paying? Well, more fundamentally, who's your client when somebody else is paying a bill? The client, who we're calling the client. I think we all know who that is. Do we owe anything really to the person paying the bills? No, not from the rules kind of standpoint. We don't. And then confidentiality. So is it reasonable to think the person paying can say, "Hey, Billy, so how's that going? Give me fill me in on what's going on in the case." Do you think that the funder would think that that would be a reasonable expectation? Yeah. But where do we stand in terms of professional responsibility? Sorry. It's to destroy the privilege with your client. Now, what's the way around it? What's the best practice to work around that? Because clearly you want to probably fill this person in.
You have an agreement, you have them both sign
So the answer from the floor is we have both people sign that say, this is the agreement. A is paying. I, the lawyer, can talk to the person who's paying, and here's the parameters of what we're talking about. Probably good to put some language in there that can be, revoked or terminated, but get that in writing up front so you don't have those issues. So what else? We got some other juicy kinds of things in here. What else do we have? Yeah, so what about this putting the money in your back pocket in cash kind of thing? By the way, can you take cash for payments? So the crowd says, of course you can take cash. And it happens all the time, particularly if you're representing people on the lower end of the economic scale. Maybe they don't have checking accounts. There are whole practice areas where there's a lot of cash. So what's best practices in terms of what do you do when somebody hands you $10, $100 Ben Franklins? You write a receipt, right. You write a receipt. Pardon me?
Blow the cocaine off.
Yeah, blow the cocaine off of it before you do that. And how about putting it, have we commingled funds if we put it into our back pocket? What do we feel about that? Is that a commingling or not?
We don't know if she had any other cash in there.
So we need to see, so if she's got her own 20 back there, we've commingled, right? And if we don't, by the way, a best practice on that is to put it in an envelope, seal it, put the person's name on it, because you gotta have some way to deal with it. And of course, cash is fungible, but at least you can actually, if you physically separate it, you're gonna be given a little bit more protection than putting it in your back pocket.
I also thought it was creepy that she called somebody to get money from them. See what I'm saying? So the client said, oh, Joe Blow might be willing to fund it. And then she made the call and had the meeting for the sole purpose of getting money. That didn't feel
So she did the fundraising. All right, now this gets really interesting for those of us who work in the nonprofit field, because let's face it, if we don't fundraise in nonprofits, the nonprofits don't get anywhere. So what kind of obligations do we have from an ethical standpoint in terms of fundraising? Can lawyers fundraise for the organization? I got some heads going up and down. Who here has actually fundraised for an organization in some way? Yeah, so we got lots of hands. So of course we fundraise for these nonprofits. But again, you need to be very careful about, what, even though it's not fundraising, it kind of is. It's getting payment of fees. You need to be very careful about how you do it and make sure everybody's expectations are the same. What else do we have in here? There was, I think, one really good one down here about this blog thing.
I think there's a question whether she's acting as an agent for them, and if she could be liable for defamation, which I'm not sure because we weren't quite catching the pains of the blog there, whether she might put them at risk.
All right, so when she's out blogging, and that's why you're here, because we blog a lot at nonprofits. So when she is out blogging, is she blogging for herself? Is she blogging for her client? How would we make that determination? Because I don't know that there's just an answer to that. What kind of factors would we look at? Okay. What else? Would disclosures help? Website disclosures are important in this. This is my blog. This is the blog for the organization. This is whoever the speaker is on these types of things. How about the and get a good lawyer, buddy. Go ahead.
It almost has to like trying to gain an advantage, or it's like extortion, like it's clearly a threat.
Well, the reason this is in here is it's actually required. When you're talking to somebody who's unrepresented and there's an adversarial relationship, the one thing you have to say is you should get a lawyer. Now, I'm not sure it should be, and get a good lawyer, buddy, you're going to need it. But keep in mind that when you're talking to somebody unrepresented on the other side, you're required to tell them, you should hire a lawyer. So that was kind of a fun twist to put in there. All right, with that, and it's amazing, but 3/4 of our time is already gone. We're going to move into the final segment here. The anti-wild cow milking bill found a new sponsor and moved through the state Senate. The effort to pass the bill in the State House of Representatives required a large public relations push, and Billy called on B.F. Franklin for more financial support. They met for dinner, and Franklin said he would give up to $10,000 to do what it takes to make this bill happen. Billy wanted to close the deal and followed B.F. Franklin home to get a check. She took a check payable to Billy Miller for 10 large. More wine flowed at the Franklin estate, as did a passionate evening that turned into an adult sleepover. Meanwhile, the Friends of Cows called Billy and asked that she join them for a special meeting. In that meeting, the group was mad that the bill would ban all rodeo events, was stuck in the agricultural committee. Surprise, surprise. We need to do something about this, said the nonprofit treasurer. The volunteer director suggested they volunteer for the rodeo, and the night before the rodeo, they let all of the livestock loose to roam free in the streets. That will bring attention to our bill, said the executive director. Billy did not say a word. And with those facts, talk amongst yourselves.
What we think. But before we get to this part, I just wanted to make a point about blogs and social media generally. Not only do we as lawyers have to be careful about our own blogging, it's a good idea to talk to our clients about social media as well. I was talking to a judge a while back, federal judge, who talked about a settlement conference he had. And the defense lawyer mentioned to the plaintiff's lawyer, do you know that your client has been blogging about her lawsuit, including conversations she's had with you? That was news to the plaintiff's lawyer. And then the judge said, and of course, I need to see the content of what she's been blogging, because everything she's blogged about now, anything that was privileged is no longer privileged. She waived that. So, just a good, story there to keep in mind. Your clients, with the explosion of social media opportunities, there are no secrets. So your client should be forewarned about that. So, aside from that, any other problems or concerns we have for our friend Billy at this point? What jumps out as the most problematic of this last scenario? Sex. I heard sex. Okay. What's the problem? Well, has she violated an ethical rule by her adult sleepover with Mr. Franklin? It depends. That's the law school answer.
So if she's clearly made the disclosure that he's only paying and she's done her job there, that he's making money and that he's not the client.
He's not the client. Well, who is her client?
The nonprofit.
Okay, the nonprofit is the client. A nonprofit isn't a person. You can't have sex with a nonprofit. But so who's the client in that context? He's a donor. She's fundraising. Well, that's never heard it called that before. But
Not clear what 10,000 is for. Maybe another profession.
well, okay, it's not clear what the money is for. Mr. Franklin says it's to do what it takes to make the bill happen. Now, there may be some uncertainty as to, is that to pay Billy so that she can do her work? Is that to make sure it will happen? I don't know, how the legislature works in this state. Maybe it's $10,000 is a little bit of grease to make the wheels work, which sounds kind of like a bribe. We don't know. Obviously, Billy would want to make clear, as we talked about before, she's getting money from the donor. What's that money for? So that's one problem. But does that make Franklin her client? Because we know you can't have sex with your client. It's just a bad idea. Okay, but is he the client?
He might think so.
Pardon me?
I said he might think so.
He might think so. Oh, well, okay. Do we know how we determine in a nonprofit setting who's the client for the purposes of this rule or other rules like client confidences? and people who we can talk to within the organization or within a different organization rather than go through their lawyer. Well, those rules get a little bit tricky. In this context, it would be either the organization's board, the people who can make decisions on behalf of the board, and any other person within the organization that's working closely with the lawyer. I still think this is a pretty tricky question when it comes to a donor. He seems to have some influence with the organization, though, and I would be pretty cautious about that.
Should have done a conflict check with the client before he accepted the money or something.
Okay, good. All right, we've only got a couple of minutes left. What about the when she's back working with the group that decides they're going to go volunteer for the radio and let all the animals loose? Did she breach her ethical obligations there?
So I'm not a lawyer or any law experience. I'm a parapsychologist actually, but to me, they probably see her as their lawyer, or she's giving them legal advice. And if she doesn't say a word and they go ahead and they let the animals loose and they get arrested, they might say, "Well, our lawyer didn't say it was wrong."
Okay, our lawyer didn't say it was wrong. You're not a lawyer, but how do you think that's going to work as a defense?
It wouldn't, but I still think that she would be.
So is she going to be in trouble for not saying anything? Does she have an obligation to tell this group, look?
Well, I think, in California, the lawyers have very little obligation to talk their clients out of stuff like this, but having worked, for the prosecution, my mindset is if they let those animals out and there's grave bodily injury or even death, that would trigger that obligation where we should at least discuss about how bad this is a really bad idea. People could die from these actions. And I think that's where it would kick in rather than if we thought of it as, maybe a public nuisance issue where you have a much lower.
Okay, so your suggestion is that because of the serious consequences that could happen, that she has an obligation now to warn her clients? Or does she have an obligation now not to disclose their client's plan to the prosecution, to authorities?
Well, there's an exception to confidentiality for crime or fraud, but I don't think there's an obligation unless there's an imminent threat to an individual.
Well, it depends is the answer. As far as whether you're obligated, it depends on the jurisdiction in which you're in. In some jurisdictions, Florida has very narrow client confidence, and the exception there is if your client intends to commit a crime, you must disclose. That's Florida. Oregon, where I'm from, it's if your client intends to commit a crime, you may disclose, which is closer to the model rule approach. It doesn't have to be imminent, by the way. It just has to be under the model rules. Has to be a threat that leads to death or serious bodily injury. You may disclose. But again, you should know your jurisdiction about what your obligations are. Certainly, she has an obligation to, I would think, to tell her client, this is a really bad idea. And I see the red dot is coming up, circle. So thanks very much. If you have any questions, we'll be around.